Resuming debate. L'honorable député de Lac-Saint-Louis.
Monsieur le Président, c'est un grand plaisir de me lever 2 jours de suite pour discuter, pour débattre de ce projet de loi, le projet de loi C-15 sur le système judiciaire militaire. J'aimerais tout simplement, par voie de préalable, dire sur le plan philosophique que le libéralisme, Monsieur le Président, l'idée à la base du libéralisme, c'est qu'on n'accepte jamais le statu quo si on trouve qu'il n'y a pas une bonne raison de l'accepter. Autrement dit, on ne dit pas en tant que libéral, bien, on doit faire ceci comme ça parce que ça a toujours été comme ça et pour aucune autre raison. Et je crois que des fois, lorsqu'on discute du système judiciaire militaire, on se repose beaucoup sur ce genre d'explications. Bon, c'est un système qui est différent et ça a toujours été comme ça parce que la culture militaire existe depuis des milliers d'années. Alors, c'est comme ça qu'on s'y prend et on doit continuer de s'y prendre comme ça. Non, c'est pas suffisant pour un libéral, Monsieur le Président. Mais j'aimerais maintenant continuer un peu dans la même veine que hier, lorsque je discutais du fait qu'un militaire, c'est un citoyen à part entière qui dispose des mêmes droits que n'importe quel autre citoyen. C'est tout simplement un citoyen qui a décidé de se donner pour son pays, de rendre service, de porter l'uniforme avec fierté, de rendre service soit outre-mer, dans une zone de conflit, ou soit ici au Canada, lorsque les militaires sont appelés à épauler les efforts de différentes collectivités lors d'un sinistre. Lors d'un sinistre naturel, par exemple, Monsieur le Président. Mais le rôle du militaire et la place du militaire dans la société a beaucoup évolué. À une certaine époque, comme je disais hier, le militaire, peut-être que le militaire était esclave, ou peut-être que c'était un militaire, un soldat à gage. Et peut-être qu'il n'avait pas le respect de ceux qui le servaient dans la société. Peut-être que c'est vraiment quelqu'un qui devait faire ce qu'on lui disait de faire, parce que, comme je vous dis, il était peut-être esclave ou soldat à gage. Mais ce n'est plus le cas. La société a évolué. Les militaires, de nos jours, se mettent debout pour défendre leurs droits. On le voit tous les jours. J'ai assis à côté de moi le porte-parole libéral en matière des anciens combattants, et il s'est levé plusieurs fois en Chambre pour demander au gouvernement pourquoi il ne traite pas les anciens combattants avec justice, que ce soit, par exemple, vis-à-vis l'effort que le gouvernement avait fait de récupérer des rentes, des pensions d'invalidité. Monsieur le Président, alors les militaires savent qu'ils ont des droits, ils sont prêts à se tenir debout pour les défendre. Alors, le militaire moderne, c'est quelqu'un qui s'attend à ce que la société lui accorde les mêmes droits qu'il accorde à n'importe quel autre citoyen, Monsieur le Président. Alors, on sait que ce projet de loi maintient un système de justice toujours à l'écart de celui dont nous bénéficions, les non-militaires, les civils, en tant que membres de la société. Et là-dessus, je vais tout simplement citer un témoin qui aurait comparu devant le comité. Et le témoin en question, il a été cité à plusieurs reprises au cours de ce débat, aujourd'hui et hier. C'était Michel Drapeau, colonel à la retraite, qui a remarqué lors de son témoignage ce qui suit. Un accusé dans un procès sommaire n'a pas le droit d'en appeler ni du verdict ni de la peine. Il n'a pas le droit à un avocat, et j'en saute un peu de son témoignage. Il n'a pas le droit à un avocat à la présence de règles de la preuve et de droit d'appel. Autrement dit, mais on l'a entendu à plusieurs reprises, le militaire doit demeurer debout pendant tout le procès dans son entier, et il n'y a pas de transcription sur laquelle on pourrait, par exemple, faire appel. Et je continue en citant le colonel Drapeau. Au Canada, ces droits sont inexistants, les droits que je viens de mentionner sont inexistants dans un procès sommaire, même si l'accusé est un ancien combattant décoré. Pourtant, tout Canadien accusé d'une infraction punissable par procédure sommaire ou civile, à l'instar du sénateur Patrick Brazeau, jouit de tous ses droits. De même que toute personne qui comparaît devant un tribunal des petites créances ou un tribunal des contraventions routières. Autrement dit, Monsieur le Président, moi j'ai plus de droits qu'un militaire accusé pour avoir dépassé la limite de vitesse que ce militaire qui sert, qui a de son gré décidé de s'intégrer aux forces armées et de servir la société canadienne, Monsieur le Président. Alors, on peut voir qu'il y a de grandes différences entre le système judiciaire militaire et le système civil. Et je comprends et j'accepte que c'est un système qui est à part et qu'il doit toujours avoir son propre caractère, mais je ne suis pas certain que les divergences devraient être aussi larges. Alors cela me rend très inconfortable vis-à-vis ce projet de loi. Autre fait à noter, et c'est peut-être en raison du fait que le système n'est pas aussi ouvert que le système civil, j'ai entendu dire que 98 des procès donnent suite à une culpabilité. Autrement dit, la personne est trouvée coupable dans 98 des cas, ce qui me semble, Monsieur le Président, un peu élevé. Alors, ça nous mène à nous interroger sur la nature du système judiciaire militaire et se demander si on ne devrait pas y apporter à ce système des changements un peu plus importants de ce qu'on apporte aujourd'hui à travers le projet de loi C-15. Mr. Speaker, I think the government needs to recognize that society in general, but more specifically in this case, the legal system, is a system of interrelated aspects that is in a kind of delicate balance. So, what may have been acceptable, before this bill, may no longer, a couple of years ago, may no longer be acceptable because a certain important change has been brought to another aspect of the legal system that means that the current system is less fair for military personnel accused of wrongdoing. And of course, I'm talking about the fact that the government has removed from the legal system the possibility of obtaining a pardon and erasing a record, based on someone's continued good behavior after a mistake that they've made. Well, when you take that away, all of a sudden, the fact that the military justice system is less fair, it becomes a bigger problem. Because now, if someone is falsely accused and found guilty based on a trial process that has not respected the principles of fairness and justice that exist even for someone who gets a speeding ticket, Mr. Speaker, then the problem is that person is really stuck. They have no recourse, and that will impede their ability to perhaps obtain gainful employment after they leave the military. And as we know, many military personnel, and again, this is something that was not recognized a few years ago, and was certainly not recognized after the Second World War. We will recognize now that many former servicemen and women suffer from post-traumatic stress disorder. So we're talking about someone coming out of the military. They may have gotten into trouble because of post-traumatic stress disorder. Now they can't get a pardon. They're out of the military trying to find a job. They may not be able to, they may be having trouble adapting to employment, to the demands of employment. And not only that, Mr. Speaker, but they're dragging this offence around, which they can't have pardoned. And so you've got a whole new set of problems that that flow out of this situation of unfairness. So we have to understand that society has changed. That here we have PTSD, which is something we didn't understand a few years ago, so this creates a problem that is just going to perhaps get worse because of not having properly thought through Bill C-15, Mr. Speaker. So as I say, there's a delicate balance, but the government has upset that balance in the judicial system by making certain changes that it thought might have some value for it politically and so on. Now I'd like to speak to the issue of the vice chair of the VCDS. I can never remember what that stands for, Mr. Speaker. Vice Chair of Disciplinary Services. Is that correct? Vice Chair of the Chief of Defense Staff. Vice Chief of Defense Staff. I'm sorry. Fortunately, I have the defense critic sitting next to me here, who's a fine defense critic and who knows this bill inside out. He's been briefing members of our caucus with great skill and knowledge on this bill, Mr. Speaker. But we have the Vice Chief of Defense Staff who can intervene in any disciplinary process. How much time do I have left, Mr. Speaker? 8 minutes. So we have the Vice Chief of Defense Staff who can intervene. Now, I would like members, especially members of the NDP, to look at the parallel here. Look at the parallel with the RCMP and the Commissioner of the RCMP. So the Commissioner of the RCMP, there is a complaints process within the RCMP regarding in cases where an RCMP member has been found to violate the code of conduct. The Commissioner of the RCMP doesn't have a right to get involved in that investigation, Mr. Speaker. Now, the members opposite say, well, it's very important that the Vice Chief of Defense Staff have that right because he can bring the operational context to bear in the disciplinary or in the investigative process. But the same could be said for the Commissioner of the RCMP. He should perhaps, the argument could be made that he should have or she should have the right to intervene because she or he can bring some operational context into the process. Well, I don't think I think, therefore, that we have a contradiction here. In the case of the RCMP, the Commissioner cannot intervene. In the case of the Vice Chief of Defense Staff, he or she can intervene. I don't quite understand why the distinction, Mr. Speaker. Now, let me just read a quote regarding the danger of this right to intervene, which I'm told is a new right, really, that didn't exist in the years preceding. But let me quote from the testimony before the Defense Committee of Mr. Peter Tinsley, the former chair of the Military Police Complaints Commission, who said, my very brief summary submission is that if Bill C-15 is passed into law in its present form, inclusive of the new subsection 18.53, authorizing the Vice Chief of Defense Staff to interfere with police operations and investigations, it will be inconsistent with the principles of police independence as recognized by the Supreme Court of Canada as late as 1999, as underpinning the rule of law, as well as run counter to the norms of police-government relations, certainly in Canada. And I can tell you internationally in developed countries, which recognize the importance of police independence and prohibit, quote, police service boards or similar executive bodies from giving directions regarding specific police operations. This is a very interesting quote, Mr. Speaker. And I would note also that other countries, we like to compare ourselves to other countries, which is proper, Mr. Speaker, because we can learn, from what is being done elsewhere, as other countries can learn from us. But I would mention that in other countries, they appear to have understood that the military justice system needs to change. That we can't just say, well, it's always been like that since time immemorial, therefore it should remain like that. I mean, maybe some people can say that, but that's not the liberal perspective on things, Mr. Speaker. Justice Gilles Letourneau, in providing criticism of the summary trial system, which remains, as I said, largely unaddressed in Bill C-15, said the following: this form of trial has been found to be unconstitutional in 1997 by the European Court of Human Rights because it did not meet the requirements of independence and impartiality set out in Article 6 of the European Convention on Human Rights. As a result of this decision and others, the British Parliament, Mr. Speaker, enacted legislation which now provides guarantees to an accused soldier. These provisions include the following: A, the accused may be represented by counsel. B, the accused is entitled to an appeal to the newly created Summary Appeal Court. C, the Summary Appeal Court is presided by a civilian judge, assisted by 2 military members who are officers or warrant officers. And D, as a general rule, imprisonment or service detention cannot be imposed where the offender is not legally represented in that court or in a court-martial. So, in our system, not only does the accused have to stand through the whole process, not only is there no transcription of the process, but the accused does not have right to legal counsel. That sounds pretty retrograde to me, Mr. Speaker. That just doesn't sound like modern Canada to me. Now, all of that having been said, I will say that there has been one improvement to the system brought through C-15, and that is, of course, to provide security of tenure for military judges so that, they feel that they can exercise their independence. So as a result of C-15, they will have this security of tenure until they reach the retirement age of 60 years, or until they are removed for cause on the recommendations of an inquiry committee, or obviously if they resign. And also, this bill will allow for the appointment of part-time military judges, which I suppose sounds like a fairly good idea. If the caseload, I suppose, is not high enough, why have a full-time judge? Or if full-time judges need some supplementary help, well, why not use part-time military judges? I don't see a problem with that, Mr. Speaker. So, all in all, we cannot support this bill. We have been consistent in our voting throughout the process, and we have not voted, against it at second reading, only to flip and vote for it at third reading, even after all our amendments have been rejected. So I think consistency is important in this place, and I'm proud to say that we will continue with our previous line of argument, and we will continue to not support this bill. Thank you, Mr. Speaker.